Okay, everyone, welcome. We are here today to do our twice a year update on what's happening with the law. And so there are a few laws that are coming down at different times throughout the year, but we want to go ahead and give you an overview of these. Some of this stuff could be legacy things that you've been doing that you think are fine and they're no longer fine. And some of them are probably things you're doing great because you're just a great employer. So we're just here to give a quick update on a couple of these major laws. And so the first one is around non-competes. And this is actually a federal law. So this is not just with the state of Colorado, but a federal law. And so John, do you want to give us an overview of what this law is?
Yeah, sure. So, last year, Colorado put limits on non-competes and non-solicit agreements. But now the Federal Trade Commission has issued a final rule that is basically invalidating non-competes nationwide. And that is set to go into effect in early September, September 4th, at least right now. So basically, except for senior executives, those non-competes are no longer enforceable, and you can't enter into new non-compete agreements. So basically, if you have any of those agreements, you should be reviewing them with your legal counsel, and you should be notifying your employees that they are no longer valid.
And they've always been really hard to enforce anyway.
Yeah.
So,
Notoriously difficult to enforce with employees
yeah,
and former employees.
exactly. So it's not, for most of us here listening, like this isn't a big deal. It's just really important though that for you to know that you don't need to do that paperwork up front because it's not no longer valid. And so it just sort of, creates one less step that you have to do when you're onboarding or you're orienting someone into your new company.
Yeah. Now, you can still have non-disclosure agreements, particularly to protect trade secrets. And that's where you really want to focus, is if there's any proprietary information or intellectual property that you feel really strongly about protecting, non-disclosure agreements are still something that you can have in place. It's just often those have been intertwined with non-competes or non-solicits, and now you have to really pull that apart.
Yeah, and there's a good reason to have the non-disclosures. So, for example, just as a reinforcement here, when you go to terminate someone or someone leaves, it's a really good idea to have a non-disclosure in place to protect the organization, protect your clients, and just kind of reinforce that they're not allowed to say bad things about you. They're not allowed to disparage you. I mean, whatever else you might want to be putting into the non-disclosure, right?
Yeah, I mean, a good separation agreement will have a non-disclosure, will have that non-disparagement clause in there, which in Colorado, actually, again, last year, there's specific language that you need to have. So that was all part of the Power Act. So if you have any old separation agreements that you're kind of recycling, you should have your legal counsel look at those again, too. And I believe in those separation agreements, particularly when you're dealing with upper level leader positions or anyone who's on the front end working with clients or sales. You want to have one of those agreements in place because you don't want ill will affecting your employer brand out there in the community. So any like investment that you would make in terms of providing a small severance gets you that separation agreement, gets that non-disparagement clause in there, and an NDA around trade secrets. And that's the thing that you really want in place, as well as to have both sides feel like they're exiting the relationship without any ill will.
Perfect. That's great. So if you want more information on that law, just reach out. We'll include it in the show notes as well. And so you'll see a link here in the show notes if you're listening. And then if you're up on YouTube, we'll put it in the YouTube comments as well. So that's one law. Now, another law that is going to affect this year that's specific more to Colorado is around applications. And so boy, do I have a beef about applications. So this is all around when people go to apply for your jobs. You cannot include dates anymore. That's the essence of this. And you can't ask when people graduated from college. You can't ask when they're mostly just college and then their birthday, right, John?
Yeah, birth or age. Yeah, it's called the Colorado's Job Fairness Application Act.
Yeah. And so this is primarily in place to protect you from, or protect the people who are applying from age discrimination, whether they're young or they're old or they're middle-aged, whatever it is. Like, you just can't do that anymore. And honestly, you shouldn't be doing that anyway, because that's just not the right thing. So you
Yeah.
can't do it by law anymore. And so don't.
Yeah, I mean, it's illegal anyway, right? It's a protected class. So age discrimination is something that, in my career, I actually have seen come up, and some claims around that, not just from applicants, but also from employees after they've been terminated. So it is insidious. It can show up in ways like, oh, I used to work for an IT organization, and the thing I heard was, well, they're further along in their career. I don't think they're going to be able to pick up this new technology. Oh, that's interesting. How do you know that? How have you assessed whether or not they can do that? Have they been given an opportunity to do that? So I was able to coach them into a different approach that steered them away from a class action suit. So
Yeah,
yeah.
good. Yeah. So that's that one. Again, we'll share it in the show notes so you can read the law. That one goes into effect when, John? Do you remember?
Yeah, so actually, July 1st, 2024. So that
Okay.
one's coming up.
Yeah, that's right around the corner. Perfect.
It is.
Okay, and the last one, the third law that we want to cover today is one that, I mean, just stick with us here for a few minutes because this is a little bit complicated. It's not fun. This is not fun. We'll just warn you. And it is so essential that you understand the details around this. And so it has to do with overtime and who is eligible for overtime based on their status as an employee. And so now you all should know this, but there's exempt and there's non-exempt employees. And there are certain roles that are by nature a non-exempt role and by nature are an exempt role. And we encounter all the time people who have misclassified an employee, have put them into the bucket of being an hourly non-exempt role, or have put them in the bucket of being an exempt role when really they should be hourly.
Yeah.
And it all comes down to then, if you are working over 40 hours a week, should you get overtime or not? And
Right.
so, yeah, so in essence, so tell us more about this one, John.
Yeah, this one is a big deal, capital B, capital D. It has been in the works for a long time. And what it is doing is raising the salary threshold for exemption from overtime, which means you have to make a certain amount of money before they'll even allow you to be exempted from overtime. Now, I want to get back to a point that you made earlier, Kendra, which is that we have seen this a lot where employers feel like it's kind of this arbitrary decision. Like, oh, well, it's easier for us we're just going to exempt everybody. And there's a couple of different categories to exempt people. They'll use the administrative exemption and they'll use it pretty broadly. But the thing is that you really have to be handling very classified information or confidential information and making decisions independently that affect the business to be able to exempt people with that. And so the other thing I encounter is, oh, well, the employee actually likes to be salaried, and so we exempted them. Like, no, you can't do that either. It is not a decision that you make arbitrarily or because of a preference. It is based on very specific criteria that is handed down from the Department of Labor. And these claims, when they come up, these wage and hour claims are so costly. What happens when Department of Labor comes in? So usually a complaint is made. It's because an employee has not been paid overtime. And the Department of Labor comes in and says to that employee, okay, so give me an estimate. Over the last 3 years, how many hours of overtime do you think you worked? And they will give a ballpark. Let's say, oh gosh, I don't know. I worked, 5 extra hours every week for the last 3 years. So then the employer owes time and a half for all of those hours, back wages, and on top of that, fines. And then it's not just that employee, it's any employee, because they're now going to dig into your entire organization and ensure that your exemptions are done properly, which are based on the responsibilities of the job and this salary threshold. So the way that is shown up very classically in the workplace is in retail, where retail establishments have exempted supervisors. But these supervisors aren't very highly paid. And actually, the majority of their time is spent doing the same work as all of their employees. But then they try to exempt them so that they don't have to pay overtime for like opening a store and closing a store, right? So the issue there, it is going to actually hit retail pretty hard. They're all going to have to raise the wages of their supervisors so they can make sure to exempt them.
Okay. Yeah. That's so good. That's so helpful. And I mean, honestly, for our listeners, I've wrestled with this a little bit too as an employer, especially on the administrative team. And it's like, okay, let's I mean, I certainly don't want to be breaking any rules, right? Or any law. Turning the corner HR is fine for HR violations. Right. But yeah, it's complicated. And so if you are unsure of if you've got the right exemptions or if exempted the right roles, just call us. Let us know. I mean, we can help you walk through this and reclassify employees and just do the right thing by the Department of Labor recommends or
Yeah, it really takes
is enforcing.
absolutely is enforcing, and it takes somebody with some expertise to go through your job description, and sometimes it even takes what's called a desk audit of like walking through with an employee, like walk me through your day. What kind of decisions are you making to really ensure that you're exempting people appropriately? And I will say, if you can get in front of it and correct the issue and potentially maybe pay some back over time that you owe, it is a lot better than having to go through an audit with the Department of Labor and the fines and the additional years of back pay that you might owe somebody. So it is better to get in front of it than be responding to an audit.
Yeah, we had a client a few years ago that went bankrupt because of this. And so it's a big deal. And the Department of Labor here in Colorado they are not ones to shy away from doing these audits.
They're
So,
not. Yeah, or the Federal Department of Labor. That's when you really don't want
yeah.
it.
Okay, well, we hope this is helpful. And again, we'll include all the information in the show notes. And please reach out. We always offer our time for free to at least get some things rolling. So let us know if we can be supportive of you. Just fill out the contact us form on our website, turningthecornerhr.com. All right, thanks everyone.
Thanks.